Hello learners, I welcome you all to the 19th lecture for the course on International Investment Law and the Environment. And in this lecture, we will be looking at investor-state dispute settlement. This is very unique. If you look at any other international dispute resolution method, you will always find state at the one side and state at the other side. So generally, all other international dispute resolution mechanism provide for state-to-state dispute resolution mechanism, be it ICJ, even World Trade Organization again talks about a trade dispute between two countries only. But it is only in international investment regime you will find an investor who can directly bring a case against the host state. So here, investor is directly suing the state. So this is very unique. And eventually, that became a very preferred method of resolving disputes. And this is something you will find in international investment agreement, either bilateral investment treaty or treaty with investment provision. This is a very popular form of resolving investment dispute. ICSID, when it proposed for the investor directly suing a host state, that immediately became popular. The reason being, the ICSID has, what World Bank has done was, it had depoliticized the investment issue. So otherwise, the investor was at the mercy of the home state. The home state may espouse his cause or may not espouse his cause. So in that context, then there is some geopolitical relationship between the home state and host state also. All of these issues are essentially addressed with giving an option for investor to directly sue the host state. Where is this consent given for an investor to directly sue the host state? Mostly you will find it in bilateral investment treaties or treaty with investment provisions, or you may find it in investment contracts also, or after the dispute has arisen, there could be a separate agreement where such a consent could be given. Is that consent something that unconditional? Sometimes in the bilateral investment treaty, there might be an unconditional consent wherein the investor can directly file a case against a host state, but it may come with conditions also. What sort of conditions? Sometimes a condition may be with regard to exhaustion of local remedies. So you cannot directly go and file an arbitration claim against a host state. You'll have to first approach the local courts, local tribunals, local administrative bodies. So once the investor shows that the investor has exhausted the local remedies, then the investor can go to investment arbitration. So that could be one of the conditions. Otherwise, there will be conditions with regard to cooling off period. Like you send out your notice of intent to arbitrate, then there is a period that is mentioned in the bilateral investment treaty that could range from 3 months to 18 months, wherein an option is given for the disputing parties to arrive at an amicable dispute resolution. It could be, for 6 months, or it could be for 18 months. If you remember Mafizini case is where they had shortened the cooling off period, right, to 6 months. Originally, the Spain-Argentina BIT had 18 months as a cooling off periods. Then Mafizini had invoked the most favored nation MFN clause. We discussed Mafizini case in the earlier video also, in order to shorten the cooling off period. So cooling off period provides you an option for arriving at an amicable solution to the dispute. So cooling off period will be discussed in little more detail in the 12th week of the course when we talk about mediation. So there we will again discuss this. So that could be, cooling off period, exhaustion of cooling off period could be one of the criteria. Condition to the consent as well, or it could be unconditional consent. Or sometimes the bilateral investment treaty may have a fork in the road clause. Either you go for local remedies or you go for international remedies, that is approach in investment arbitration. So, but you cannot take a U-turn and all of that. So that may be the provision. So then there are any other pre-arbitration steps that are mentioned there. Basically, the condition with exhaustion of local remedies or cooling off period, they can also be considered as pre-arbitration steps as well. And any number of things could be mentioned. For instance, the Model Indian BIT says that at least in a domestic setup, the investor has to try for domestic remedies for a period of 5 years. I mean, the case could be resolved before, but if it is not resolved within 5 years, then they can directly approach. So all of these, the pre-arbitration conditions can also be set out in the bilateral investment treaty itself. Okay, so ISDS has successfully depoliticized, but that does not mean that ISDS is not with problems. ISDS has a lot of problems, especially with regard to legitimacy, with the cost, it's very expensive, and also with regard to when it comes to expansive interpretation given, an inconsistent interpretation given by arbitral tribunals. That is also a problem that is attributed to ISDS. And there's no appellate mechanism. So the inconsistency is not addressed. And then some feel that there's no balancing of investors' rights with that of public policy as well. So the policy space of the host state as well. So that is also criticism leveled against this. Are there any mechanism to improve all these? So basically, you can address it with your treaty itself. One of the reasons why ISDS is criticized as incoherent is because on the same facts, you find multiple decisions by different tribunals. Take the Czech Republic case itself. CME and Robert Lauder, both these cases have essentially the same facts, same measure was challenged under two different bilateral investment treaty, and the decisions again differ, right? So that inconsistency is again highlighted in terms of ISDS. A lack of appellate mechanism further strengthens it. So some bilateral investment treaties itself provide for bilateral appellate mechanism that is being explored. Or again, we will discuss in the 12th week of the course with regard to appellate mechanism and with regard to EU's proposal for establishing multilateral investment court as well. So these may address some of the issues. And legitimacy is also a concern. Most of these arbitrations happen in a closed door. There are around 600 plus ISDS that have happened, known ISDS, because since confidentiality, since this is completely a party centric process arbitration, some of the awards of the arbitration is not released to the public. So in that case, there may be some investment arbitration which is not revealed to the public as well. So now if we see that so many cases have been filed in context of investment arbitration, then the legitimacy issue is also there, because most of the measures that are challenged in ISDS relates to regulatory measures taken by the government by exercising its sovereign right. So in that case, when the government has exercised a sovereign right and the same is challenged before an investment arbitration, in a closed mechanism where the party submissions may not be revealed to the public, award may not be revealed to the public, legitimacy comes into picture. And where does the cost is also sometimes may be prohibitive, because an MNC may be in a financially a better position compared to a host state government, where it has to be very wise in spending the taxpayers' money, right, the public funds. But an MNC could spend the money, and then they may be in a position to better afford the lawyers and all of that. May be easier for them to fight an investment arbitration compared to that of the host state. So cost may be prohibitively high as well. Compensation is the only remedy that you get out of ISDS. Right, so only monetary compensation. Unlike trade dispute, in case of a trade dispute, either you have to withdraw or modify the challenge trade measure, but that's not the case in the investment regime. Only monetary compensation will be awarded to investor. Counterclaims are now coming up. There's not much jurisprudence, but counterclaim, we'll very briefly discuss about it while discussing Avon versus Costa Rica. That's it, but it's not yet developed. What are the institutions that administer investment arbitration? The most popular one is ICSID. ICSID, as you know, International Center for Settlement of Investment Disputes, was envisaged particularly for settling investment disputes. So ICSID is very popular. ICSID will administer ICSID convention provisions as well as ICSID arbitration rules. ICSID can be a dispute resolution forum if both the home state as well as host state are signatories to ICSID convention, and then ICSID can be the forum to administer arbitration. But sometimes what happens is only one of the country is a party to ICSID convention. In that case, ICSID allows for invoking ICSID additional facility rules. So then ICSID AF, additional facility arbitration, can happen mostly in the context of NAFTA, all Mexican cases where ICSID additional facility cases. India is also not a signatory to ICSID. So Indian cases are administered by ad hoc arbitral tribunals, and then unsettled arbitration rules is relied on by India. Using unsettled arbitration rules for settling investment disputes is not new to bilateral investment treaty practice, treaty era cases. This is something we can see in the context of Iran-US claims tribunal itself. I mean, ideally, unsettled arbitration rules is envisaged to settle international commercial disputes, but they are actually used for settling investment disputes as well. So, Indian disputes, investment disputes that were filed against India, that were under unsettled arbitration rules. And then there could be other forums like LCIA, PCA, and all of these that could also, act as arbitration forum for settling investment disputes. It's a voluntary process. Generally, the bilateral investment treaty itself will mention what rules will be applicable, which forum will be applicable, all of these get set out. But even if that's not set out, there could be a subsequent agreement post the dispute has arisen between the disputing parties, and then they could accordingly take it. When there are a lot of criticisms with regard to ISDS, we can currently see that UNCITA Working Group 3 is looking at reforming ISDS. They have identified certain reform elements, and all of these are currently being discussed in the context of Working Group 3, especially the appellate mechanism as well as the possibility of establishing a multilateral investment court or mediating investment dispute. That probably could become the future, because even ICSID had come up with mediation rules in 2022. Even UNCITRAL had also come up with guidelines with regard to guidelines on mediation for international investment disputes as well. So maybe mediation could also pick up for settling investment dispute as well. But whatever criticisms are leveled against ISDS, you cannot deny that ISDS is very unique, and it has successfully depoliticized the investment dispute from that of political consideration. And that is very essential, because especially if you look at the NAFTA context, Article 1128 allows non-contracting parties. I mean, let's say if a Canadian investor has brought a case against United States, Mexico and Canada also can submit written submissions under Article 1128 of NAFTA. So if we see that, all host states take a united view. So investors' own home state may take a view that's contrary to investors' interest as well. So in that context, this depoliticization, an investor can directly sue the host state, is something that's very beneficial to the investor. So I think this marks the brief background with regard to ISDS. You have to have a little bit of understanding about ISDS in order to better appreciate the cases that we will be discussing in the 6th, 7th, and 8th week of the course. Thank you.